in the way in which we manage concessions on public land.
Mr Chair, I actually wasn't going to take a call on this part, but the Minister's response has led me to do that, and it is around well, he is an inspiring man. It is around section 18122 and the question of reducing the time for objection or submission to 20 days in the case of a concession. And I think it's 2 points I want to make and then a question. The first point is the one is actually Eugenie Sage referred to it, but in passing, which is that we're talking about public land. That's the thing that makes this distinctive. While it's possible for RMA-related cases to have that, it has to be public land in this case because it's docks and docks' interest. And that's what makes it different. And going back and actually, I think Eugenie Sage might have been working on the Conservation Act in 1987 in a different guise. There was clearly an intent to make the time frame longer. 40 days is actually a very unusual time frame in terms of the law.
It's not a notice on a neighbouring gate.
Yeah, that's right, exactly. It's not a notice on a neighbouring gate, as David Parker says. We are talking about complex, often controversial concessions to public land being protected. It doesn't get much more important than that, and therefore 40 days is a sensible time period for that. And I think that is the distinction that's been missed here. And reading through the departmental report, Mr Chair, it's clear that the Department of Conservation, when it undertook its concessions processing review in 2010, went looking for ways to streamline the process of concessions. And there may well have been some justification around elements of that. What it says in the departmental report is they were looking for, as I say, ways to streamline the processes, increase transparency and reduce compliance costs. That is all very well and good. But as we have stated time and again in this debate in the last 2 days, all of this law, be it law within the Resource Management Act or here within the Conservation Act, is about striking the balance between the way in which we allow sustainable development to occur and facilitate the public to be involved. This is a classic piece, this clause, of unbalancing that situation. By all means, find ways, and there are in earlier clauses in this part, of streamlining the process, but let's not sacrifice the ability, as David Parker has noted, often of small-scale community groups to be able to participate in what is a large and significant, often, concession about public land. Now, having made that point, Mr Chair, and very much supporting David Parker's typescript, as they say, SOP on this matter, to return us to a 40-day level, I want to ask the Minister what consideration was given to submitters who came up with other alternatives, one of which was a 30-day time frame rather than the 40-day or 20-day, which would align it with some other pieces of legislation that have been passed by this House, or whether or not there was the ability to define large and complex concessions, which would be at 40 days, and then less complex concession one at 20 days. Obviously, as Mr O'Rourke and Mr Parker have now both said. I would seek some feedback from the Minister, because it would seem to me that simply blanketly going from a 40-day process, which has been in place, we've just been celebrating the 30th anniversary of the Department of Conservation, it's been in place for 30 years, stood us in good stead as a country. To make that change on a blanket basis seems to me to deny the importance of that land to many New Zealanders and the importance of the process of going through and allowing time for submission. So, we oppose this part because of this clause, but I don't think I've heard a sufficient explanation from the Minister as to why he may not have considered some of those in-between options. But overall, this remains unfortunately symptomatic of this whole piece of legislation, that in the Minister's rush to appear to do something about issues within resource management, he's chosen to accept a reduction in the ability of the public to be involved in really important concessions about public land.
The Honourable Ruth Dyson.
Thank you, Mr Chairman. I want to pick up the contribution that my colleague was making just in passing, because what I want to really focus my contribution on is clause 182, which hasn't been discussed much this evening already, and I think it deserves it. So the Minister has been assuring us throughout this debate that the point of this is to reduce bureaucracy, streamline the process, but not to cut out the opportunity for people to have their legitimate say. And I believe that he's genuine in his consideration of those facts, but I don't believe that it's reflected in the legislation that we're discussing at the moment. So the alignment in this Part 4 that we're discussing is between publicly notified concessions to the Department of Conservation and resource consent applications. So the new provisions are that the Minister of Conservation has 10 days to decide whether a concession application is compliant or non-compliant. The intent to grant notification is replaced, and I appreciate the Minister taking the flak in this debate for the notification of the monorail. It actually wasn't his error that caused that, if my recollection is right. He inherited that from a previous Minister of Conservation and got it sorted out with a very wise decision. And I hope he always sticks to that. It also reduces, and this is the bit that's been contentious in the debate so far, reduces the timeframe for public notification to receive submissions from 40 days to 20 days. A number of people have contributed in this debate to say how unrealistic that is on matters of such importance. The Minister has been the Minister of Conservation and the Minister for the Environment, understands the complexity of some of the proposals, understands the deep pockets that some of the proponents have compared to the not-for-profit organisations or the communities themselves who are having to rally together evidence, expert witnesses, a lot of information in order to be on a level playing field to contest the application if they disagree with it. And 20 days is unrealistic. So I want to challenge the Minister to support the supplementary order paper that's been tabled by my colleague, the Honourable David Parker. I think soon to be supported by a replicate supplementary order paper in the name of David Seymour. That seems to be the pattern of SOPs at the moment, and to say that this debate has been right on this single point, and 40 days is far more appropriate. Mr. Chairman, as I said, though, that isn't the main point of the contribution that I want to make. I was outraged when I saw a major change that was made to clause 182. So a submitter came to the Select Committee and said, by the way, we've got a really great idea of how we can make other processes more innovative. The submitter was Oceana Gold, and they thought that it would be useful, I think, was the word they used in their submission. Yeah, it would be useful. So they said that the alignment of notification timeframes could usefully be extended to include publicly notified access arrangements under Section 61C of the Crown Minerals Act, and for mining activities on conservation land notified under Section 49 of the Conservation Act. Minister, you know, I know that the Minister is well aware of what people view mining applications on conservation land. The Minister has been at the receiving end of that response, but has allowed this amendment to be made to clause 182 of the bill, which enacts Oceana Gold's submission without any public input at all. Nobody knew that that submission was being made until it was made public, by which time the submissions had closed. Oceana Gold's submission was not made public, as the Minister is well aware. He's been in this Parliament a long time and follows the rules carefully. That submission was not made available to the public until after all submissions had closed, and nobody had an opportunity to cross-submit, if you like, on it. Nobody had an opportunity to make a contribution. That is cheating the public's view Mr. Chairman.
Honourable Ruth Dyson.
That is cheating the public's right to have a say in a fundamental policy position such as this. I think Oceania Gold have got every right to make a submission. The Minister's got every right to agree with their submission, but to have it snuck in as a change at Select Committee and then only notified to the House once this bill had been reported back, no chance other than through the committee as a whole to debate this very point, I think is the Minister is better than that, actually, would be my frank assessment. There is no need to have this change made. It wasn't part of the alignments that are sensible in principle, and some of the detail is wrong in this particular area, particularly the reduction of public input from 40 days to 20 days. But Mr Chairman, I would urge the Minister to consider over the dinner break, if we haven't voted on this part before then, that Oceania Gold decided that this change was useful not in the public interest, not in the interests of having less bureaucracy and more efficiency, but in the interests of them being able to access Crown land for mining. That wasn't the point of the resource management legislation. If that's a minister's decision, if a minister from the National Party says we've decided that conservation land is no longer to be protected for future generations, we're happy, National Party might say, we're happy to open it up for mining in much bigger areas than it currently is. That's a debate the public can have, and it can go through a proper process. This doesn't do that. It goes through quite a weak process. Mr Chairman, I'm really pleased with the way that the debate has been going so far, because it's covered a number of different provisions, and for those of us who are not on the Select Committee, this is the only opportunity that we get to hear the details that Select Committee has been going over for some time. Each of these parts has got major changes to different legislation. That's quite a bold move for a minister to take. I don't think that in the previous part he got it right. I was very disappointed that the minister didn't take an opportunity to answer the question that I raised, but I certainly hope that he will better reflect on the contribution that's been made in Part 4 in regard to changes to the Conservation Act, supports the SOP from David Parker, and also looks at a change to Clause 182 so that that submission from Oceania Gold is either able to be debated publicly or just put to the side. It's cheating the public's right to have a say by including it in the bill in this way.
Members, we move to the vote on Part 4. First